That was Detective Justin Livingstone of the Rochester Police Department who investigated this case. Now, remember, after that attack happened, the defendant in this case, he fled the scene. Jordan Lamonde took off, and police had no idea who had done this. They had the surveillance video, but Lamonde is wearing a hooded sweatshirt. Couldn't really get that great a look. They didn't know who he was, so they released this video to the public, asking the public for help, right? We hear it all the time. If you know anything about this incident, if you recognize anyone, give us a call. Sure enough, they got a tip, and that's what led them to Lamonde. We just heard the detective talking about how they went to Lamonde's house and they found a vehicle that matched the description of the vehicle that was in the parking lot at the time of the attack. So Adam Sostrin, criminal defense attorney, still with me via Skype. The fact that he fled the scene, I mean, not surprising. I'm sure he didn't want to be caught, but does that, you know, add to the severity of this at all?
It's unrelated, but it shows consciousness of guilt. It's something that could go to the jurors as part of an instruction fleeing from the scene.
Yeah, I mean, we've been talking about this back and forth, whether or not prosecutors will be able to prove that this did rise to the level of second-degree aggravated assault, right? Because they have to prove that he had a blatant disregard for whether or not Aaron would survive. So what is your take so far on what we have heard? Because I mentioned our Law and Crime host, Bob Bianchi, was on a little while ago. He and I were talking. He said, you know what? This guy might just get a lesser charge. They may not be able to prove it. What do you think?
Well, I tend to go for more the conservative side. I mean, the fact that he shows, he certainly shows a blatant disregard for her by just running away from the scene. So why didn't he do it when he was punching her 40 times in that short period? So I don't think the jurors would have trouble getting to a guilty verdict on this.
Yeah, I mean, it's just guilty, I guess, on which charge. You know, when this came out, police said this was a vicious, unprovoked attack that shocked our community. And that was at the time when they made the arrest. Again, the 18-year-old victim in this, Aaron McCarthy, luckily was okay, did not endure any lasting physical effects from this, and apparently, you know, seemed emotionally okay all this time out. You know, we will hear something from the defense, we expect tomorrow. Do you think they'll call any witnesses in this, or, you know, what more can they do at this point than to try to just say, look, the prosecutors did not prove without reasonable doubt that he, you know, had this, you know, depraved indifference or, you know, whatever disregard for her?
Yeah, I don't know if they're going to be calling anybody. Of course, they do have the. I mean, they certainly can't call a character witness to show that the defendant's not a violent person, so that's not going to happen. Honesty is not going to have anything to do with anything. Nobody's going to care. The defendant himself, it's possible if the defendant prefers, he can, you know, tell his attorney and insist it's his constitutional right that he can testify and tell them, no, it wasn't my intention to hurt her that bad. I just punched her a few times, not too hard. I've gotten in fights before, and no, I wouldn't want to, you know, I would never want to kill somebody. And, you know, who knows? I have no idea what's going to happen tomorrow. They might just rest on the state of the state's case.
Yeah, they might. It is expected to be a quick one. So, again, that trial will resume 10 a.m. tomorrow morning out of Rochester, New Hampshire. We will have the live feed as soon as it does. Let's take a break from talking about this case now and take a look at today's top crime stories.
Here are today's top crime stories trending on lawandcrime.com and across the country. A teen in Texas is facing 2 counts of murder after he reportedly left 2 toddlers to die in a hot car. 18-year-old Kevin Frank was arrested and initially charged with 2 counts of manslaughter after he allegedly left the 2 toddler sisters in a hot SUV for 15 hours while he partied with their mother before they died. The mother of the toddlers, 20-year-old Amanda Hawkins, was also arrested and charged with 2 counts of injury to a child and child endangerment. An entire police force in Southport, North Carolina is suspended after the chief of police was arrested on corruption charges. The former chief, Gary Smith, and Lieutenant Michael Christian Simmons face charges of felony conspiracy to obtain property by false pretenses, willful failure to discharge duties, and obstruction of justice after it was discovered that both men were moonlighting as truck drivers while they were supposed to be on duty, often leaving the city and state. The entire police department is placed on paid administrative leave. A Penn State fraternity member who was charged in the fatal hazing of Beta Theta Pi pledge Tim Piazza will avoid spending any time in prison. Ryan Burke, a frat brother at Beta Theta Pi, pleaded guilty to 4 counts of hazing and 5 alcohol violations after Piazza died from injuries sustained while falling down a flight of steps at a fraternity event. The fraternity was soon closed, and other members still face charges. Burke was sentenced to 27 months of probation, fined more than $3,000, and ordered to perform 100 hours of community service. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Thanks for that, Anthony. Well, I have Adam Sostrin, criminal defense attorney, with me live via Skype this afternoon. Thanks so much for being with us, Adam.
Always fantastic to be on Law and Crime. Unfortunately, means something awful happened in the world, but I love talking to you guys.
Well, let's talk about this case we just heard Anthony recap, the Penn State frat case, the fraternity death, right? One of the frat brothers killed during, or not killed, died after being injured during a hazing incident. And now the first frat brother to go on trial for these charges dodges jail. Ryan Burke, the judge sentenced him to 3 months of house arrest. He also will serve 27 months of probation and be fined more than $3,000. He also has to do more than 100 hours of community service. Is this a harsh enough penalty when you have another frat brother who's dead because of what happened during this night of hazing? Prosecutors allege that Ryan Burke was one of the ringleaders here, making the frat brothers drink 80 proof vodka, do all sorts of crazy physical stunts.
Well, if they wanted to set a precedent for the future, you know, for people not to engage in that kind of behavior, the judge certainly didn't do that. Obviously, it's pretty unbelievable. I feel like people get more time for peeing on a tree. 27 months probation. You know, even if you're upset there was no jail time, the fact that it's 27 months probation, that's surprising to me. Most misdemeanor cases that I'm aware of are 3 years probation, and somebody died here. So it doesn't make a whole lot of sense to me.
Yeah, I mean, there's several other fraternity brothers who are also facing charges. Those cases will be making their way through the legal system in due time. I'm wondering, you know, what, if any, sort of influence does this sentencing have on those cases now? This guy walked with no jail. He was the alleged ringleader, so can we assume that the others will do the same?
Yeah, we can assume the others are going to do the same or a little bit less. So what else can you assume? It's a surprising, and you know, if I were the judicial officer in this case, I think I might want to do a little bit more than what this specific judge did.
You know, it's interesting because the family of the victim, Tim Piazza, that was back in February 2017 when he died after that night of heavy drinking and hazing at the fraternity Beta Theta Pi. His parents said that they were, you know, satisfied with the outcome of this, and that it was sort of like the beginning of the path to closure for them. In essence, you know, they said of their son, all he was trying to do was join an organization and make new friends. But their attorney called this sentence an important step on the long road to justice. And he did note at least it included the loss of freedom of the admitted perpetrator of the crime because of the 3 months house arrest. Is 3 months house arrest a big deal, you think?
I don't think it's a big deal. Of course, the family wants closure. The family wants any which way not to look at this. The fact that there was some kind of sentence meted out and there was a guilty plea, maybe that's all they look for. That's all they really care about. Or maybe it's not. But the fact is they probably just want to be done. They want to be done with it. They want to remember their son. They don't want to hear anything more about the court case. I can't blame them for that. I feel terrible for them. We all feel terrible for them.
It's like one of those sad stories, I mean, where this is another student. It's not like this is a career criminal we're talking about here, right? These students all had presumably bright futures ahead of them. Nobody wanted anyone to get hurt that night, whether they were negligent in planning this or not. And so, you know, it's possible the family feels, well, that's, you know, sufficient punishment, you know, let him go on and live his life and have a future, even though their son can't. So
obviously, it's understandable. Obviously, they're not career criminals, but I kind of think the point of our judicial system sometimes is to establish deterrence. I didn't see it happening here.
Yeah, I agree with you on that one. Well, let's move on now to the Jordan Lamonde case out of New Hampshire. Lamonde charged with assault for beating up a woman as she left a Planet Fitness back in 2017.
Well, I don't go. That's why I don't go to Planet Fitness. I don't go there.
Okay, well, we can't blame Planet Fitness in this case. We don't want to make them look bad, because what if she had been walking out of a New York sports club or a Retro Fitness or an LA Fitness or whatever it was, right? I mean, this was the wrong place at the wrong time, perhaps. Right. There are suggestions from prosecutors that Lamonde attacked this woman because he believed her boyfriend had stolen money from him. The case is on a quick break right now. We have seen a steady stream of prosecution witnesses today. We are expecting to hear from at least one more witness before court wraps up for the day. In the meantime, I want to discuss it, Adam, but let's listen to some of the prosecutor's opening statement just to hear how they're arguing their case. Okay. We hear the judge saying that concludes the witnesses for the day in the Rochester, New Hampshire courtroom where the second-degree assault trial is going on against Jordan Lamonde. We just heard from Officer Brittany Marvin with the Rochester Police Department talking about responding to the scene and interviewing the victim in this case, Erin McCarthy, this woman who was walking out of Planet Fitness. There you see that it was all caught on tape when Jordan Lamonde goes in and begins hitting her repeatedly, hit her some 40 times in the head, beat her up. The allegation here is that Lamonde was angry at Erin McCarthy's boyfriend, believed that he had stolen thousands of dollars from Lamonde. So Lamonde now facing second-degree aggravated assault charges. And joining me live via Skype is criminal defense attorney Adam Sostrin. Adam, let me ask you, if you're this guy's defense attorney, you've got the act caught on tape here, so it's not like you can try to argue he didn't do it. What would be your strategy?
Mitigation, 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 mitigation. That would be my strategy. He's caught on candid cam. What are you going to do about it? It was a brutal attack. It was awful.
Yeah, I mean, and totally, for this woman, random, maybe she knew of him, but certainly wasn't expecting anyone or didn't think she had, beef or problems with anyone. We just heard the officer testify about how shaken up and terrified the victim was when she responded to the scene, how she had been hit in the head so many times. Right. When I first read about this case, of course, my first thought was like, why didn't this guy just take a plea? Because it's caught on tape, he did the crime. What's your thought on that? I mean, we don't know for sure if a plea was offered, but in a case like this, is it typically offered?
I don't know what the conversation was. It almost seems like the lawyer's only left with, well, he thought it was somebody else, or this was stated to the police. It was the boyfriend that was involved. He was very upset. Maybe that helps him out with sentencing. Probably with most judges, it's not going to make an iota of difference. You got plenty of clients when you're in this business that they just want to go to trial for whatever what, or the offer that was made just was so bad. It didn't make any sense for anyone to take that offer, and they took it to trial because they're thinking, well, maybe the judge will make a better deal. I don't know. I don't know what happened behind those backroom doors or those conversations that he had with his client.
Well, let's go ahead and listen to the defense opening arguments and see how they laid out their case, and then you can tell me whether or not you think they did a good job.
There you go. There you go. Okay.
Well, there you have it. Part of Jordan Lamonde's attorney's opening statement, the defense attorney arguing that, look, this was an attack that lasted less than 30 seconds. Yes, it looks bad, but there were no weapons used. There were no verbal threats. She was able to walk on her own, get her things together after the assault. And he points out she didn't have any really serious injuries. Yes, she was shaken up, but she did tell investigators later on that she was doing okay emotionally. Therefore, this defense attorney says he should not be convicted of second-degree assault, second-degry aggravated assault. So Adam Sostrin, a criminal defense attorney with us via Skype, how do you think he did? Do you buy it that, look, it was a bad attack, but he didn't do it with intent to cause her grave injury? He didn't have a weapon. This shouldn't be aggravated assault. What do you think?
Well, one of the things they have to show is extreme indifference to human life. And his argument to the jurors is this person didn't have any weapons, which obviously would show extreme indifference to human life. the attack was so quick, perhaps it was meant to be just a quick little scare, a beat up and a runaway type thing. Then maybe he's hoping that he can get a lesser included rather than the second-degree assault charge in which he's currently charged. So I thought he did a fine job. Yeah, he
On
did
the
well.
other hand, if it only took 30 seconds, fine. He still hit her in the head 40 times. That
40
doesn't
times.
sound like just a quick little scare.
No, don't think that that's what I intended. I mean, that's what he's going for. Obviously, that's what the prosecutor's going to say. Come on, he could have killed the person, and he's lucky that he didn't. But if that's all he has, then I think he's successfully conveyed that.
Yeah, well, we'll see. It is going to be a quick trial. We're going to take a quick break. When we come back, we're going to have much more discussion on this and other top legal stories making news today. Stay with us. We'll be right back after this break. Welcome back. That was Erin McCarthy, the assault victim, up on the stand as she described leaving the Planet Fitness back on June 12, 2017, walking to her car when all of a sudden the defendant, Jordan Lamonde, came up from behind her and began hitting her, beating her on the head. She said she didn't try to fight, but she did just run off. She went back to the Planet Fitness. She was able to do that. So she was well enough to be able to walk away. Adam Sostrin, criminal defense attorney, what did you make of her testimony? She didn't seem too emotional one way or another, really, in my opinion.
Well, she didn't, but it didn't happen just yesterday.
Right.
She was able to walk away from it. I'm sure she was pretty emotional right after it happened. And, of course, they need their witness to testify, and that's precisely what she did.
Yeah. Were you surprised at all that she didn't get into, more detail about how she felt at that moment? We heard the final witness of the day just a little while ago, the officer who interviewed her, saying how shaken she was, how emotional she was when she responded to the scene. We didn't really get that from the victim herself.
This is one of those rare times where you don't even need that. First of all, not everybody testifies the same. It didn't just happen the other day. And you've got this thing right on camera. So she just needed to say, just the basics of what occurred and nothing else. And I don't think it would make a difference with respect to the jurors and whether or not they're able to make a finding as to whether or not the defendant was criminally indifferent or not.
Yeah, I mean, it's caught on surveillance video, and it's played over and over and over again in this trial, in the openings, as witnesses testify. What effect does that have on jurors for them to see this clip over and over again?
Well, it's not a good effect. It's not helpful if you are the defense attorney. It's really not helpful if you're the defendant, and I'm sure the prosecutors love it.
All right. Well, I'm sure they do. We're going to take a quick break. When we come back, more discussion on this case and other top legal stories that we are following all across the country. Stay with us. We'll be right back. Well, that was some of the testimony from Dr. Joseph Wu, who examined the defendant in this case, Anthony Kirkland, who looked at some of his brain scans. And Dr. Wu, we just heard say that it seemed that he had traumatic brain injury, and also that there were several incidents in his childhood that would lead to that, including his father beating him from a young age, hanging out with older men who drank and were involved in violence. He said when he was 36, he had a bike accident and a facial fracture. He became a different person after that. So Adam Sostrin, criminal defense attorney, still with me here via Skype. Adam, I always wonder when I hear this, the defense obviously is going to put up whoever they can to say, look, these are the reasons this guy should not get the death penalty. There was trauma, there was abuse in his life. In your experience, does this sell to a jury? Just because a lot of people have been abused, right? A lot of people have had really traumatic childhoods. That doesn't mean they go out and murder 5 women.
Right. I mean, he was hit in the head 4 or 5 times and he had a bike injury. I don't know if it's compelling enough to make the difference with the jurors. For the sake of, let's say, the justice system, though, I think it's a good thing that the sentencing matter is being retried, the penalty phase, because it was an egregious error for the prosecutor to say that it wasn't sufficient for the jurors to only give a life sentence. I know that.
Let's go back to that for 1 second, right? Because, yes, you're right. That is why the death sentence was thrown out, because the prosecutor in the last case said, you know what, sentence him to death, because if not, it will be like these two other women are freebies, is what he said, because he was already, Kirkland was already serving a life sentence for the other murders. Can you explain to our audience why that was wrong and why another court then overturned the death sentence because of that?
Well, it's egregious error. No party is supposed to comment on punishment when they're making their closing arguments, or at any point with respect to sentencing phase of a trial. Should deserve this because they're sort of taking over the juror's role, and it is incredibly prejudicial to have somebody who has the authority of the state to say this is insufficient, you must do this. So that's why it's unacceptable, and that's why it was overturned, because it's a big deal. It's a type of error that a prosecutor shouldn't make. And I think oftentimes, and I am biased because I'm a defense attorney, but I think oftentimes prosecutors go a little too far in their closing arguments. That's
right.
Just how
I mean, you had said they're not supposed to comment on the penalty, but obviously they can say why their argument for why the defendant should get the death penalty. But in this case, I guess yes, as you said, and as an appeals court agreed, what he said went too far. So, did you want to add something? I didn't mean to cut you off there.
No. I'm agreeing with what you're saying.
We're going to take a quick break. When we come back, we're going to talk more about this Kirkland case. Plus, we're going to talk about the other big case making news across the country today. That is the trial of Paul Manafort, happening right now in Washington, D.C. That is coming up. Stay with us. We'll be right back after this break. All right, so that was some more from Dr. Joseph Wu. That was prosecutors cross-examining him after he testified that the defendant in this case, Anthony Kirkland, had 4 separate incidents that would lead to traumatic brain injury, talked about a bike accident, talked about his father beating him from a young age. And then we heard the prosecution challenging him a bit and saying, yeah, but I thought that his change in personality wasn't attributed to the bike accident, but to him hanging out with older men who drank and did drugs. That's what his mother had said. Adam Sostrin, criminal defense attorney, still with me via Skype. I mean, what is the distinction here? What difference does it make if they're saying his personality changed because of a bike accident, which would be beyond his control, presumably, or versus just from hanging out with a bad crowd of older guys who drank and did drugs?
Well, they're trying to shed doubt on the causation. That's the prosecutor's job at this moment. It's the defense expert who's testifying saying this is the basis for it, and the prosecutor is entitled to say, well, wait a second, what about all the bad people that this guy was hanging out with for this length of time? Couldn't that have had any effect? And just to make the jurors sort of doubt, the sincerity that the defense expert has with respect to the only reason why the defendant behaved the way he did, maybe it's not... it's nurture, not nature, and the nurture being with respect to, hanging around with bad guys.
Right. This doctor, these doctors who are expert witnesses like Dr. Wu, what goes into sort of determining on his part whether or not someone like Anthony Kirkland really suffered trauma and abuse, right? We know he interviewed him and talked with him, looked at his family history. What else goes into this?
They talk with them multiple times. There's usually more than one visit when they meet with the defendant. They conduct all kinds of tests, which I do not understand. Afterwards, sometimes, if there's enough money for it, if you can get the state to pay for it, or if you're a private client can afford it, they'll do some kind of a brain scan to say, hey, here, there's something going on here. This is different than everybody else, and this could explain the behavior. So they even go that far.
Yeah, Wu said in his testimony that his analyses of Kirkland's brain showed severe neglect and abuse, and he called it the perfect storm when it came to failures in decision making. Again, you know, you can be mad at making decisions, but that's very different from going and raping, killing, in some cases burning the bodies of young women, right?
Right. Yeah, I would be upset, actually, if I retained an expert who got on the stand and said language like, you know, the perfect storm, for instance. You don't want hyperbole from a person where hyperbole is not supposed to be part of what they do. It makes it seem as if they're just a little bit less credible, and perhaps you can indeed rely on the prosecutor's cross-examination of the expert.
Well, we know another big part of this case is that jurors are hearing depositions, previously recorded depositions from both Kirkland himself and family members of the victims. One of those victims, Esme Kenny, just 13 years old when she encountered Kirkland and when he raped, killed her, then burnt her body. Certainly a brutal, horrific crime. Let's now hear a little bit from Lisa Kenny, Esme Kenny's mother. We've been listening to Sergeant Jennifer Mitch from the Cincinnati Police Department, who responded to the scene back in 2009 when Esme Kenny had gone missing. A search ensued. As we just saw, they showed some of her clothing. We know this was a really, really brutal attack. The 13-year-old girl was raped, killed. Her body was burnt. They had to use dental records to identify her. She had just gone out for a jog with her iPod when she literally ran into Kirkland, and he proceeded to attack her. Adam Sostrin still with me via Skype, criminal defense attorney. We know this is, as we've been talking about, obviously, a resentencing trial about whether or not Kirkland should get the death penalty. So we know he's already been found guilty of all of this stuff, all of these crimes. But when the witnesses talk about the scene, they go back to those scenes. When we see the pictures from the crime scene of the girl's torn clothes, what does that do to jurors?
You have a young girl here. It obviously bothers them deeply. And can they take the testimony of Wu and sort of go around that and say, well, he had some type of irresistible impulse. We can't give this guy the death penalty. It's a tough case for the defense.
Yeah, I mean, I think a lot really also depends on the jurors, the local jurors, right? I mean, we know that one Ohio jury already decided that he should face death. And of course, it only takes one person who feels strongly that he shouldn't. But what do you think jurors are looking for or want to hear or feel like they need to hear as they make this literally life and death decision?
Well, I think they're looking for some ounce, a kernel of mitigation, which it's really hard to find with the evidence that they're being presented with. That's what they're looking for. Can they indeed rely on the defense's expert? Is that enough? Or is it just enough that this person did horrible things and hung out with horrible people? So who's to say that the person who evaluated him is correct? And we need to punish this person. He did something wrong. It's an extremely difficult case for the defense. The prosecution has all its ducks in a row here.
And no surprise, that expert who we heard from earlier, Dr. Joseph Wu, the prosecutors really tried to discredit him. They said, you know, have you testified in a lot of cases? He said, no, only a few, really sort of trying to poke holes, you know, in his arguments, in his ability to testify as an expert witness. We're going to take a quick break. We will be right back with much more, including some discussion about the Paul Manafort case, coming right up after this. Was a previously recorded police interview with the defendant in this case, Anthony Kirkland, as investigators pressed him for details on what he did to his victim, in this case, Esme Kenny. Adam Sostrin, criminal defense attorney, still with me here for the long haul. When the jury hears from the defendant himself, this was taped many years ago, we know, before the other trials. He's admitting to the crimes. This goes on and on as he describes stomping the girl, eventually raping her and killing her. I mean, this is the, you know, they're hearing the confession with their own ears, right?
Right. They're hearing everything, and it shows how good the investigator was at getting those statements from the defendant and the kind of things that they have to do, how they have to speak to them to get what they need. And it's obviously very damning.
Well, yes, damning indeed. We will see how the jury weighs it in the end. That's still a little while off. In the meantime, court going to continue first thing tomorrow morning in Ohio. Of course, we will have all of the latest live on Law and Crime. Well, before we wrap up for the day, Adam, I want to talk about the other big trial that everyone is talking about all over the country, and that is the trial of Paul Manafort, the president's former campaign manager. It got underway yesterday in Virginia. Manafort on trial for basically orchestrating a conspiracy to avoid paying taxes on millions of dollars he made working for Ukraine, working for pro-Russian officials in Ukraine. So I want to talk about some of the highlights today in court from what I'm seeing, from what's come out of court. And the first thing is, Adam, yesterday everyone heard the recaps. We read the stories in the papers today. We heard about this lavish lifestyle that Manafort lived. We heard, he bought a $20,000 watch, a $15,000 ostrich jacket, drove a Mercedes. He's got houses all over the place. But today the judge actually reprimanded prosecutors a little bit. He said, you know what, they're harping too much on Manafort's luxurious lifestyle. The judge, Judge Ellis, said, look, he's not on trial for having a lavish lifestyle. He also told prosecutors to stop using the word oligarch when they refer to the people in Ukraine that Manafort was working for. Why is that a big deal? Why is it a big deal if they keep playing up his lavish lifestyle, or if they use the word oligarch? In your mind, why would the judge want them to stop doing that? How could that influence the jury?
Well, first of all, after we have this conversation, I'm going to go back to the Men's Warehouse and find out if this is ostrich. I'm not sure.
It doesn't look it. No offense.
No. So the idea being that it's incredibly prejudicial. He's working for an oligarch. He has a lavish lifestyle. He's doing this. He's doing that. The prosecutors are trying to show, obviously, that he made a lot of money. This money wasn't given back to the U.S. government, but it was spent on these lavish items. They're trying to show, how much money he had, how brazen he was, and that's why they're doing these things. But you can't go too far. You can't sort of miss the point of, did he make money? How do we know he made money? What were the items that he possessed? Rather than going into, some of the creative adjectives they're using, I'm sure it's annoying for the judge to hear that. It's a little bit, let's say, a leading type of strategy from the prosecutor, and it can be slightly annoying for any judicial officer to hear that over and over and over again. So I get it.
All right, we may not hear more about the ostrich jacket. The other big headline so far today is that prosecutors said that Rick Gates, that's the man that's supposed to be their star witness, may not testify. Now, they didn't say he wouldn't. They just said he may or he may not when asked. Now, they have 35 witnesses. This is just one witness. But remember, Rick Gates was Paul Manafort's partner in this. He is cooperating with the government against Manafort. If he doesn't testify, what does that mean for this case?
Well, if he's cooperating with the government and the government needs his testimony, it could affect what kind of, if there's been some sort of offer of leniency that the government, is trying to use with respect to, what kind of sentencing he's going to end up getting in the case. So
Adam, let me cut you off right there. We've gone too far. It's time to say goodbye. Thank you so much for joining us. Thank you to all our viewers. We'll see you back here first thing tomorrow morning.